this person been redeemed, right? Is this person suitable? If they transformed enough to be able to enter society, it's more likely, I think, that you look at the person who is white, and it's more likely to attribute their past to situational factors. The final thing we'll talk about, this is a picture from a case called Kelly versus California, okay? And its victim, it's a terrible picture. Nonetheless, it's a victim impact testimony. How many people know what victim impact testimony is? So in capital cases, okay, at the end of the case, jurors are able to see it's supposed to be, the Supreme Court says, a brief glimpse or a snapshot of the victim's life. We want to let people know that the person who's died is really a person, right? Because the trials are often about the defendant, what the defendant did, right? The defendant's life. And we want to know that the person who's killed is a person too. So we allow people to have a brief glimpse. Well, it turns out we don't actually have a brief glimpse in most trials. This is a picture from Kelly versus California, where Justice Stevens wrote a dissent from the denial of certiorari saying, it was supposed to be a brief glimpse. This is like a really long video. We have music in the background, right? We have pictures growing up for childhood. This isn't the kind of brief glimpse we're looking at, right? And so think about that victim impact testimony and think about juries in capital cases. For the last 35 years, consistent findings across a number of state and the federal death penalty, there's a finding that the victim's race matters. When the victim is white, the person is more likely to get a death penalty, whether the defendant's white or black. The key point is the victim white? But when the defendant's black and the victim's white, you're the most likely to get the death penalty, right? So think about this victim impact statement. Most jurors in capital cases are white. You're looking at this video and you see this white person, right? And they're going through and you see the picture, blonde hair, blue eyes, and you think, as a white juror, think about the pain study, the empathy, the extension of empathy, right? That could be my sister or my neighbor or my cousin, right? I can see myself in their situation. I see the loss that the family is going over to. You can put yourself in their shoes, right? And so without consciously thinking about this value, this life is worth more than the life of a black victim, I think that the implicit favoritism helps to explain it. The very last thing I'll say is that Justin and I ran a study on an implicit association test where we used the value of life, we called it. And so we had people pair words like expendable, right, for value or valueless with other words like worthy or words that connote value, right? And we found out that people associate words that connote value with white Americans relative to words that connote a lack of value to black Americans, right? And so we've shown that there's an implicit difference in how we value human life.
Thank you for having me, and this is at least considerably different from Rob and Justin's conversation, which depresses me every time I hear it because it teaches me how sowed into the seeds of racism America's death penalty and criminal justice system is, and how much work there is to remove it. In 1963, there were 21 executions. Ohio, then as now, was a northern leader in the use of capital punishment. 1963, as those of you who begin to take death penalty jurisprudence will find out, is 4 years away from the beginning of what became the Furman moratorium. Furman happened in 72, but they stopped executing defendants in 1967, 68. And then after Furman in 72, there's what I think is described as the backlash to these civil rights efforts, the Voting Rights Act, the Civil Rights Act, the Housing Act in the 60s. There's a backlash to those efforts at at desegregation. And in 1976, the United States Supreme Court reallows or reinstitutes capital punishment in Gregg versus Georgia. And what you saw in Gregg is contemporaneous to and is part of this politicization of crime that continues with Nixon, with Reagan, with George Bush. It is the Willie Horton, for those of you who are sort of my contemporaries, the Willie Horton and George Bush's effort to secure election. And it's this larger battle over the course of America that we are still in the process of fighting. Today, in the United States, we've had 21 non-volunteer executions this year. And that number has gone up, and it is coming back down to that pre-Furman era level. As Rob says, race continues to play this central role in the application of the death penalty, most particularly, as he notes, in terms of who receives it and for what crimes, but also in respect to the juries that impose capital punishment. We see over and again the juries that are imposing capital punishment are either all white or almost all white, majority sentences imposed on minority defendants. And the third way I see race devastatingly play out in capital punishment is structurally that states and communities accept and tolerate capital punishment because it's being imposed on individuals that are not themselves. They see it as being imposed on the other. I'm going to get to Shelby in a moment, which was this awful U.S. Supreme Court case, which I think we'll understand as the McCleskey of our time in a second. But there is this inexorable connection between full suffrage, meaning the full ability for everybody's right to vote, and capital punishment. Because I think at the end of this, you don't have a capital punishment where you have full suffrage. Where you have full suffrage, you have full access to justice, and where you have full access to justice, you don't have capital punishment. And Dr. King said 50 years ago, we refuse to believe that the Bank of Justice is bankrupt. So this is Caddo Parish in 2010, and in case you couldn't see it, that's the Confederate flag flying outside of Caddo Parish in 2010. A short history lesson about Louisiana and Caddo Parish, which is not taught in Louisiana schools, is that post-Civil War, immediately in the 1860s, following the Civil War, blacks and Republicans at the time, the party of Lincoln, believed in full suffrage for African Americans. So blacks and Republicans outnumbered Democrats. And in Caddo Parish, over 500 people in the 20 years after, 500 African American men were murdered, lynched, barbed wire killed in the years that followed emancipation and the provision of suffrage to blacks in Caddo Parish. So Caddo Parish, which started after the Civil War as being predominantly African American, became predominantly white. And Caddo Parish, like the rest of Louisiana, and so in 1898, the Louisiana Constitutional Convention was an all-white, they described themselves as a lily-white convention of Democrats. Democrats were, at the time, the party that wanted to deny African-American suffrage. And E.B. Krutschnix, who was the chairman of the Democratic Party and led this convention, and whose picture, when you walk into the Louisiana Supreme Court, E.B. Krutschnick's picture is on the wall on the left as you walk in, and we honor him. He said, "We have not been free. We have not drafted the exact Constitution we should have liked to drafted because of the 13th, 14th, and 15th Amendments. Otherwise, we would have just inscribed it, if I know the popular sentiment of the state, universal white manhood suffrage, and the exclusion from the suffrage of every man with a trait of African blood in his veins." So that was the goal. They weren't allowed to say it the way they wanted to say it, so they wrote it differently. What care I whether it be more or less ridiculous or not? Doesn't it meet the case? Doesn't it let the white man vote? And doesn't it stop the Negro from voting? And isn't that what we came here for? He sought the hegemony of the white race. And that was the historical context which brought that monument to the Confederacy and put it in front of the courthouse in Caddo Parish. And so when jurors went to Caddo Parish courthouse to serve, African American jurors walked past that flag and that monument to the Confederacy. In 2009, Felton Dorsey, 17 African American men have been convicted and sentenced to death out of Caddo Parish. It's a small parish. It's outrageously disproportionate to the number of death sentences that there are in the country, in the state. But when citizens went to serve on juries, and the parish is still, and was at the time, 49% African American. African Americans would say, we don't want to serve on a capital jury. And a single juror specifically explained to the judge, I don't want to, Carl Staples, I don't want to serve because there's a Confederate flag that's hanging outside, and that's a symbol of the greatest crime that this country's ever committed. How could I serve on a capital case and decide whether someone should live or die underneath that flag? And he said that flag deserves to be in a museum that we learn about, not hanging consecrated in front of a courthouse. And the court removed Mr. Staples for cause because he refused to consider the death penalty in a capital case with a flag hanging out front. And so this is how capital punishment, it's how 17 African Americans end up getting sentenced to death by all white juries or almost all white juries in Caddo Parish because of this operation of death qualification, this removal of individuals of conscience. The devastating circumstance of Shelby. In Shelby, the United States Supreme Court said, racism's over in America. We no longer need to protect communities. We no longer need to prevent voter disenfranchisement. That the efforts of E.B. Krutchnik are finished. And Shelby, to me, captures this two versions of America, right? There's Chief Justice Roberts' version of America where E.B. Krutchnik never existed, there was never intentional racism, that we've resolved our problems and everything's fine. And then there's, in Justice Ginsburg's, and you need to read her dissent where she describes both the circumstances of racism that continue to occur in the United States, but also the protections that the Section 5 of the Voting Rights Act provided. And one of the places it was providing that protection was in Caddo Parish. And I'm going to tell you in a second about how that flag came down. And that flag came down because of the protections of Section 5 of the Voting Rights Act. But you look at that opinion and you get this picture of two Americas. You get the America where everyone's treated equally, and then the America where it's not. It's the America where you're better treated by the criminal justice system if you're wealthy and white than if you're poor and black. So this flag came down. I'm going to cut dramatically. This is the section, this is where the Voting Rights Act, Section 5, applied to constrain the efforts of state governments to disenfranchise African Americans. And there was a community of folks working for 50 years to bring the flag down in Caddo Parish. It was not an easy effort. But students from places like Case went to Caddo, white and black, and worked with the community and said, we will support you. Charles Ogletree came down in 2011. We will support this. It can no longer be in America that a flag stands outside a state courthouse, like the Confederate flag, and that the demographics shifted. The Voting Rights Act protected the franchise, and the flag came down. And it came down. And there's a beautiful. You can hear watch the hearing online. People came up and white and black ministers came up and pledged allegiance to the flag of the United States of America. There's nothing more haunting or beautiful than watching people stand up and repeatedly say the Pledge of Allegiance to the flag. But that racism still exists. Two other community members stood up and said that the flag shouldn't come down, that Lincoln hadn't freed the slaves, that Martin Luther King was wrong, that the slaves of Caddo Parish had never been slaves. So for Justice Roberts to talk about how racism is resolved, and that some of the members of the county commissions who sat up there said, well, we should bring the flag down, but we should do it with all deliberate speed. And one of the commissioners' response to that was, I think tomorrow morning at 10 a.m. it seems to be the deliberate speed that we look to. I know that you're going to give me a 1 minute in a second. But Caddo Parish is not it's unique in how bad it is, but it isn't unique in its circumstance. And this is the connection that you trace between lynching, capital punishment, and these disenfranchisement. And because as Rob talks about the new Jim Crow, capital punishment is this kingpin of the effort to disenfranchise African Americans. It allows you to sentence a 9-year-old to life with the possibility of parole only because there's capital punishment. Those horrific and draconian sentences for marijuana crimes are only available because we also sentence people to death. You can see the locations where the death penalty. I think in my lifetime, in your lifetime, in your work lifetimes, we will see the end of the death penalty, and we will see it because if you give full suffrage to a community, it understands that people facing capital punishment are human beings. This is my last story, and then I'll let you close me off. You guys can ask questions. So Philadelphia, like Cleveland, has awful crime. Capital cases always involve awful crime. It involves someone's been murdered. And this is a case, there were multiple defendants. 2 of them were facing life or death. And the first defendant had lawyers who were, I think, institutionally designed not to provide quality representation. He got death. And the second defendant had lawyers who at least tried to contextualize Mr. Northington's life. And in the federal death penalty, which has a series of problems, is a vast location for racism in the United States. But Stephen Northington, in federal death penalty, you're allowed to write in mitigating circumstances. And so this jury, when they were explaining why they unanimously voted for life for Mr. Northington, for the same crime that his co-defendant received death, and it's the same jury, but it's just after a different presentation. What they wrote in is that Stephen Northington is a human being and his life has value. And with full suffrage, without exclusion, that applies to everybody. And it is this, I saw it, and it is this like haunting reminder of what Dr. King taught us in Memphis, that if someone is a human being, you don't kill them. And when you see them as other, you accept their death. So I think we are almost there. Thank you.
welcome. I'm going to be the last official speaker on the program, and so after I am done, I'm going to open it for questions. And my presentation is going to be pretty short because we're going to have a symposium in April that is going to focus on the Civil Rights Act, the 50-year anniversary of the Civil Rights Act, but particularly Title VI, which is also used for education, but in the area that I write on, I focus on access to health care. And so I am just going to focus today because the majority of the panel has been on implicit bias in the healthcare system. But I also recognize that racial disparities are caused by institutional bias and structural bias. So if you want to find out more, come to the talk in April. So I want to start off with a quote from Martin Luther King. Of all the forms of inequality, injustice in healthcare is the most shocking and inhumane. Now, when we look at where we were before the March on Washington, healthcare was separate and unequal. And in fact, the funding source for a lot of hospitals, nursing homes, specifically gave out funding if it was separate, but it never reached the equal part. Today, healthcare remains separate and equal. And in fact, I was on a plane ride talking with somebody from Case, and he was talking about how when he went to medical school in the 1980s, I'm not going to tell you which one, that when he visited the hospital, they still had separate facilities. So in 1987, they still were not putting the black babies with the white babies, okay? No, it was not in Ohio. And so when we look at the progress that we have claimed to have made, just remember that when we said that everyone had the right and had equal rights, that did not happen right away. And in that hospital, it didn't happen until after 1987, okay? Research studies show that in 1950, before the end of legalized racial segregation, the life expectancy rates of 65-year-old African American males and Caucasians were the same. Since that time, African American mortality rates, when compared to Caucasians for cancer, diabetes, suicide, and homicide, were higher than they were in 1950. And in fact, we haven't seen a decrease in the disparities between mortality rates between African Americans and Caucasians since 1945. So we still have a long way to go. So today I'm going to briefly talk about racial disparities and equality, racial bias, particularly implicit bias, and give you some solutions and conclude. As was referenced a little bit earlier, we can see there are lots of studies since right around the 1990s, all the way up until now, that find racial disparities and equality. There are Medicare disparities, disparities in lung cancer and pneumonia. Let me talk about that a little bit. In 1996, the New England Journal of Medicine published a study regarding racial disparities in the provision of Medicare services. And Medicare is what you get after you reach the age of 65 or if you're disabled, and everybody gets it. Everybody gets the same amount. Okay, but what they tend to find is that still, even when you're dealing with Medicare patients, that physicians treated African American Medicaid patients less aggressively than Caucasians. So it's not just about what lots of people like to say, it's because you can't pay for health care. No, it's not because you can't pay for health care, it's because we're still looking at the race of the individual patient, which should cause us some pause when we look at healthcare reform. Healthcare reform is great because it will increase access to health insurance for people. But just because you have the health insurance the same as somebody else does not mean that you're going to get the same care. In 1998, a study found that African Americans were less likely than Caucasians to receive curative surgery for early stage lung cancer, which is linked to increased mortality rates of African Americans. If African American patients had undergone this surgery at a rate equal to Caucasians, their survival rate would approach that of Caucasian patients. So that means you're not getting the care, which leads to death. A 1998 Harvard study found that African American Medicare patients received poorer basic care than Caucasians who were treated for the same illness. And this is particularly in the case of pneumonia. The study showed that only 32% of African American pneumonia patients with Medicare were given antibiotics within 6 hours of admission, compared with 53% of pneumonia patients, Caucasian pneumonia patients with Medicare. And these studies show that the failure to get the antibiotics leads directly to increased deaths of African Americans. And in fact, by 2002, an estimated 83,570 African Americans had died each year that would not have died if the death rates were equivalent to those of Caucasians. And so I did the math. If we go back from 1960 to now, that means approximately 4.2 million African Americans have died unnecessarily because of these healthcare disparities. We can also see these disparities in nursing home care. A 2000 study of several states, including Ohio, found that when Caucasians and African Americans reside in the same nursing home, the quality of care provided to African Americans is worse. Data showed that late-stage pressure sores are more common to African Americans, while early-stage pressure sores are more common to African Americans. And I'm not going to gross you out because you ate, but I want to talk a little bit about pressure sores. So basically, if you're laying in the bed, you don't move for quite a while, then your skin begins to wear down. An early-stage pressure sore is when your skin just stays the same color. Doesn't change color because now you're starting to bruise. By the time you get all the way to the end where we're talking about late stage pressure sore, we're talking about surgery because now you have no skin in that area. And what we tend to find is that traditionally you see African Americans who are, when they're first diagnosed, they're at the point where it's
Is this